Joining us today for this perspective on the second founding event hosted by the First Amendment Center. This will be a discussion with Professor Ilan Wurman and William M. Carter Jr. I'm going to go ahead and introduce our speakers today, and then we're going to hop straight into the arguments. I'll be monitoring the chat today, and so if you'd like to, you can throw any questions into the Q&A. And for our folks who are here, you can raise your hands whenever we get to questions. But with no further ado, we'll do some introductions. William M. Carter Jr. is a professor of law at the University of Pittsburgh School of Law and led the school as dean for 6 years from July 2012 to July 2018. Prior to joining Pittsburgh, Carter was a professor of law at Temple University's Beasley School of Law and Case Western Reserve School of Law, focusing his scholarship in areas of constitutional law, civil procedure, political and civil rights, and litigation. His academic writing has appeared in Columbia Law Review, the UCLA Law Review, the UC Davis Law Review, Emory Law Journal, and the Texas Law Review, among others. Professor Ilan Wurman is an associate professor at the Sandra Day O'Connor College of Law at Arizona State University, where he teaches administrative law and constitutional law. He writes on administrative law, separation of powers, and constitutionalism. His academic writing has appeared in the Yale Law Journal, the Stanford Law Journal, the University of Chicago Law Journal, the University of Pennsylvania Law Journal, the Duke Law Journal, and the Texas Law Review, among other journals. He is also the author of A Debt Against the Living, An Introduction to Originalism, and The Second Founding, An Introduction to the 14th Amendment. Yeah. Okay. Professor Carter, if you'd like to start with your argument, go ahead. Thank you.
Certainly, I'd be happy to, and please let me know if you all can't hear me okay. It's great to be here with you. I'm sorry I couldn't be there in person, particularly since I heard there were breakfast tacos. So if someone wants to mail me a breakfast taco, that would be great. Don't put a taco in the mail, please. The discussion for today, I prefer to think of as a discussion rather than an argument. I'm really looking forward to it. And I'll get right into just an overview of my work in this regard. But first, I'd be remiss if I didn't give some thanks to everyone in attendance, as well as all the staff there and faculty who pulled this together. Double thanks to the editor-in-chief for stepping in on very short notice. That's very gracious and kind of you. And thanks in particular to the Texas Law Review for not only publishing this article, but giving me an opportunity to talk about it in this forum. So what I want to do is to be relatively brief and go over the top of the themes of my article, The Second Founding and the First Amendment. Happy to take a deeper dive into any of the details during the discussion and Q&A, but both because I look forward to the discussion, but also I want to leave enough time for my co-panelists. I will be purposefully brief in terms of summarizing my article. As I was preparing for the talk today, I was thinking about how I would describe the article, and I think it's really about three things at a big picture level, all of which I've been thinking about for some time, and all of which came together in this work. The first is that it's about constitutional interpretation. How do we interpret the Constitution? What is our touchstone? What is our frame of reference? And what evidentiary sources matter in constitutional interpretation? The second is the field in which I've done most of my scholarly work, dealing with the legacies of slavery. That is the presence of the past in the present, if you will, the ways in which slavery distorted and shaped American society, and therefore the ways in which the Second Founding sought to remediate those distortions and harms. And then last, bringing to bear those first two lessons on the First Amendment and thinking about what we have to learn from the Second Founding period that may inform our constitutional jurisprudence. So on the first, this insight is not novel to me. Many other scholars, Akil Lamar, Bruce Ackerman, and many others have contended that the period of time beginning with the 13th Amendment in 1865 and following with the 14th and 15th Amendments, as well as the burst of civil rights legislation and executive action thereafter, amounted to a second founding of the nation. It was revealing to me when I first started studying the history of the law and slavery exactly how deeply the issue of slavery was permeated within our constitutional fabric from the very beginning. It perhaps should not have been surprising, but it was not a subject that I explored in any depth in my law school curriculum. Once you begin exploring that history, you see that the all-consuming issue in American society from the moment of the founding onward was the question of slavery. How to reconcile the birth of a new nation, ostensibly founded upon Enlightenment ideals of equality and liberty, with the reality of millions of persons, first indigenous persons, and then African captives, being held in enslavement as chattel without rights. That question was something that absorbed the founders. As most of you know, it is also something that resulted in a variety of constitutional compromises that at minimum tolerated the existence of slavery and at maximum gave it affirmative constitutional protection. The slave regime that existed from, just to pick convenient dates, 1619 to 1865, interestingly, existed for 250 years approximately, so significantly longer than the period in which we have had formal freedom from 1865 to 2022. It therefore should not be surprising that it permeated all of our legal institutions, nor that after the Civil War, in attempting to reconstitute a nation that had been broken apart by a horrific war fought on American soil, that second founding would attempt to undo and remediate the legacies of slavery. What is interesting to me is that in the Supreme Court's jurisprudence, and I think this generally holds true for most lower court cases engaging in constitutional interpretation as well, the general assumption is that there is a single through line running from the time of the original founding, 1787, 1791, to today, that there is an uninterrupted constitutional regime whereby if, and I emphasize if, one believes that evidence of either the original understanding or original public meaning informs constitutional interpretation today, the relevant data point, the point in time that you look for that evidence is 1787 or 1791. To me, that has always seemed to be a flaw in constitutional interpretation in as much as it ignores what Akhil Amar calls the jagged gash in our constitutional structure represented by the Civil War, a break between the prior regime, under which chattel slavery was a fundamental component of our legal and economic order, to one thereafter where all persons, at least under the law, were to be treated as worthy of equal dignity. And years ago, when I first started reading the framing debates around the 13th Amendment in particular, I was surprised at how radical the Reconstruction's framers' goals were with regard to the new constitutional regime that they believed they were shaping. They did not believe that they were merely outlawing whips and chains and the legal property relationship of chattel slavery, but also, in the words of Charles Sumner, that they were to undo the legacies of slavery, the badges and incidents thereof, in their language, root and branch, any remaining vestiges of the system of African slavery, those framers believed, would be outlawed under the new constitutional regime, and further believed that the federal government had not only the power, but the duty to remediate those legacies of slavery. And so on the first general theme of my article, what I tried to do is make a case that we, the collective we, have unfairly overlooked this second framing period. And we therefore assume that the first framing's values carry forward to today unchanged. I believe that assumption is incorrect. And looking at the First Amendment is one way to illustrate the differences in the constitutional values of the second founding. The second broader point is thinking about the legacies of slavery in general. So I had been writing about the 13th Amendment for many years before embarking on this article. And one of the things that I learned in reading the legal history around the second founding was that the legacies of slavery were deep and far-reaching. There's the clear economic legacy, the theft of labor. There are some legacies that are more generally known, such as the severance of familial relationships, the denial of rights in court. And there were also some legacies that were more systemic, that is how we think about rights. Things like, for example, the state action doctrine reflects a particular view of the post-Reconstruction jurisprudence in terms of how far we as a country would go to seek to dismantle the legacies of slavery. One particular legacy of slavery that greatly occupied the minds of the framers of the 13th and 14th Amendments, but also, to my surprise, when I began reading slave narratives, was also something that many enslaved persons themselves talked about, thought about, and wrote about, was the denial of freedom of speech, conscience, and information represented with regard to enslaved persons themselves, number one, as well as abolitionists, number two. The battle over slavery, as it began to heat up in the early 1800s, largely became a battle over ideas. And the ground on which the early abolitionist movement chose to wage the battle against slavery was one of what they called moral suasion. The idea was to convince the people in the slaveholding states and the people in the non-slaveholding states to abolish the institution of slavery and to grant full civil rights to the persons who had been subject to it. The slaveholding states and the friends of the slaveholding states elsewhere, rather than seeking to wage a battle on equal ideological footing, did what tyrants always do, which is to outlaw the expression of dissent against a powerful institution. And so in law school, if you've taken First Amendment law or even con law, what you generally would have picked up was that the first big moment in our history regarding free speech was the Alien and Sedition Act in the late 1700s. And then the next big moment was in the early 1900s in the Red Scare period. I would contend that the ideological battle over slavery and the suppression of Black and abolitionist speech concomitant thereto was a larger free speech moment in the minds of the people who lived through it than either of those two moments. The ideological battle over slavery was fought in part by formal laws suppressing Black speech and abolitionist speech, but also a great deal through private action, whether it is the private action of the slave owner or that of the organized mob, who employed terroristic violence on a widespread scale to silence Black speech or speech about Black freedom. Mobs lynched, murdered, chased, beat, tarred and feathered, literally, anyone who had the temerity to suggest that the system of slavery was immoral and inconsistent with our constitutional values. In this article, although that history is not as well known as I would like, there are many people, Michael Kent Curtis and quite a few others, who have written about the ideological battle regarding slavery and free speech from the perspective of the dominant class. That is, abolitionists who were famous and well-known, slaveholders who wielded economic and political power. What I wanted to do in this article was to look at this issue through the lens of the persons who had been enslaved. So about halfway through the article, I paused to make the case about if you are interested in excavating the original understanding, then it seems to me that you should also be interested in the expressed views of enslaved persons as part of the contemporaneous original public understanding. I hasten to add, I am not an originalist. I believe originalism is a tool. I don't have a particular philosophical commitment to it. But if we're going to employ the tool, it seems to me that we should employ it in its most fulsome manner. And so the article makes the case that although it may seem odd that enslaved persons, who by definition were not part of the constitutional polity at either the first or second founding, should have their views taken into account with regard to constitutional meaning. I think that view is wrong, at least if one is following original public meaning originalism. It is the views of the contemporary public, which would include people who were enslaved, not necessarily empowered stakeholders. That is the touchstone to excavating the original public meaning. So after trying to make that case, and again, I'm happy to talk about any of the details during the Q&A, the article then turns to what I think is the primary novel contribution, which is illuminating and excavating the views of enslaved persons on freedom of speech. As I mentioned, one reason to do that is that it just provides another relevant body of evidence for understanding the meaning of the second founding and how it may affect our interpretation of first founding constitutional provisions. The second reason, though, that I chose to focus on elevating and excavating the views of enslaved persons is not necessarily because their positionality gave them unique insights, although in some cases it did with regard to freedom of speech, but more so because our distance, in part our distance in time, but also in part the moral distance we have chosen to take from the institution of slavery, blinds us to the fact that these were real people living real lives in a system of nearly unimaginable brutality. And I think we owe them something to understand what they lived through, what they hoped for, and what they thought the new and hopefully more just society built by the second founding would embody. And so I spent quite a bit of time looking at a wonderful repository. The University of North Carolina has an online repository of maybe 1,000 slave narratives. And I read hundreds of them, looking for information in slave narratives where enslaved persons from a first person perspective express their views and experiences about freedom of speech. And I will not read those lengthy quotes to you, both for the sake of time and for the sake of not boring you. But it was surprising to me how highly enslaved persons valued freedom of speech in the sense of freedom of information, freedom of communication, freedom of conscience. So they spoke, for example, of denials of the right to practice religion in a collective setting of their choosing as a denial of their right to conscience. They spoke of their experiences being brutalized whenever they had the temerity to speak back, to contradict a white person. They spoke of what today we would call compelled speech, instances where they were forced, upon pain of severe punishment or death, to profess their fealty, loyalty, and affection for their masters. They spoke also at great length of what we would call today viewpoint discrimination, that the hand of the government in enforcing or not enforcing the guarantees of freedom of speech always weighed most heavily in favor of those who spoke for oppression and granted them the greatest license to speak, while at the same time employing draconian legal and extra legal measures to silence those who spoke in favor of equality. And the last point that I will make here, and I'll give the rest of the time to my co-panelist, Professor Wurman, is this: abolitionists and those enslaved persons who had the good fortune to be able to think at all about things beyond their immediate existential needs did not fear a fair battle regarding the morality and constitutionality of slavery if it would be fought fairly. What they resented deeply, deeply was the government privileging anti-equality speakers while at the same time suppressing pro-equality speakers. And so I think as we think about how contested the value of free speech has become today, and I certainly, like everybody else, have a lot of critiques regarding our contemporary First Amendment jurisprudence, I think that it is worth not losing sight of those who lived through the second founding and how they thought about the value of freedom of speech. Indeed, the American Abolitionist Society, the primary abolitionist organization in the mid-1800s, in its Declaration of Sentiments, expressly noted the value of freedom of speech in achieving equality and stated that we believe that citizens have the right to express and publish their opinions on the Constitution, laws, and institutions of any state and the entire nation, and we mean never to surrender the liberty of speech, of the press, and of conscience. And so I would just offer this as a closing thought, To the extent that there are real conflicts between the constitutional values of expressive freedom and equality and anti-subordination, they are ones that the law needs to reconcile. I, however, am reluctant to believe that those always must be in tension, as seems to be a sentiment that's pretty widely shared today, because history teaches us that that's not true. In fact, one of the primary tools for achieving equality and anti-subordination has always been robust protection of the freedom of speech of those who strive and fight to achieve equality. I will stop there, and I look forward to Professor Wurman's remarks and some dialogue.
Thank you, Professor Carter. Professor Wurman, the floor is yours.
Thank you. Well, thank you so much for having me here, and for those of you who show up in person and online. I had the opportunity to read Professor Carter's article, which is really, really fantastic, and I think largely consistent with what I'm about to say. So in my book, it's a short book, it's about 140 pages, so kind of like it's a long, large article, so it's really not that long, which is, I think, its greatest virtue. But it makes an originalist case for the 14th Amendment that I think actually better accounts for the objectives of the Black voices that Professor Carter advances and articulates and I should say exhibits in his paper. And so I think this is an originalist argument that better accounts for a lot of their objectives and interests. So I am an originalist. I consider myself an originalist. I write in the originalist space, so that's where I'm coming from. So the argument here is all on the basis of the privileges or immunities clause of the 14th Amendment, the clause that provides that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. This is the clause that almost everyone agrees, all the scholars that Professor Carter mentioned, Ilan Wurman, Michael K. Curtis, other originalists like Randy Barnett, believe incorporates the Bill of Rights against the states, that makes the freedom of speech applicable as a matter of federal First Amendment law against the states, and it is through that vehicle that Professor Carter wants these slave narratives and other Black voices to affect a sort of First Amendment cases. Well, my claim in the book is that incorporation is wrong. It is originalist gospel today across all, and non-originalist gospel, that the privileges or immunities clause was intended to incorporate the Bill of Rights. But I think it's wrong. I think this clause was intended to be an anti-discrimination provision with respect to civil rights under state law. And there are lots of implications for the First Amendment, which I'll get into. But just so we're clear what I'm talking about, I think this means that California can ban handguns. What California can't do is say only white people are allowed to have guns. It can't do that. California can require a license to operate a laundromat in a wood building. What it can't do is grant every white applicant for the license, but deny every Chinese applicant the license. So those are the stakes that the states can continue to define and regulate the content of civil rights. They just can't discriminate in the provision of those rights. Okay, what is the evidence for this? I'm going to start with that sort of elite class of abolitionists and Republicans who drafted, and then I'll try to shore that up with some evidence of Black voices as well. So it is essentially undisputed that the principal objective of the 39th Congress of the 14th Amendment was to constitutionalize the Civil Rights Act of 1866. So the key to uncovering the meaning of the privileges or immunities or the amendment is the Civil Rights Act of 1866. So what was the Civil Rights Act of 1866? Well, after abolition, after the Civil War, the southern state governments tried to reduce the newly freed population to a system as near as slavery as possible, without it being slavery, though it was basically slavery de facto, in the so-called Black Codes. So in these Black Codes, the southern government systematically denied basic civil rights to the newly freed men and women in the South. So for example, in these Black Codes, it said that persons of color could not own real property. White people could own real property, white citizens could have real property. The newly freed people were not allowed. The newly freed people were not allowed to assemble. The newly freed people had to enter into certain kinds of contracts every year, employment contracts, lest they be deemed vagrants, right? I mean, this is basically a system of slavery. And they weren't allowed to own guns, right? They said no dirks, daggers, swords, firearms, or munitions of any kind. All of these things not applicable to white citizens. Hence, the Civil Rights Act of 1866 declares that all persons born in the United States and not subject to any foreign power, and excluding Indians not taxed, we have to bracket that for now. Otherwise, all persons born in the United States are citizens of the United States, and such citizens of the United States shall have the same right in every state and territory, right? So such citizens of the United States of every race and color, shall have the same right in every state and territory to make and enforce contracts, to sue, be parties, give evidence, to inherit, purchase, lease, sell, convey, hold real and personal property as is enjoyed by white citizens. So note what the Civil Rights Act does and doesn't do. It doesn't nationalize rights. It doesn't define or guarantee any of the rights it lists. The states can still regulate and define property and contract, but it just says whatever rights a state gives its white citizens, it must also give its black and other citizens. Okay? Now, it is beyond dispute. So it is an anti-discrimination statute with respect to civil rights under state law. Now, it's beyond dispute that the 14th Amendment was necessary and was motivated in part by the need to supply a constitutional basis for the Civil Rights Act. Where does Congress, look at Article 1, Section 8, where does Congress get the power to interfere with the tort, property, contract law of the states, the stuff of your 1L courses, right? It's black letter 101 that the original Constitution doesn't give that power. Some people thought maybe the 13th Amendment enforcement power would. There's no question that they wanted to give Congress a basis of power to enact this law. And also what happens when the Democrats take over, which they did in 1875, what's to stop them from repealing the Reconstruction Republican civil rights legislation. So you need to enshrine this equality requirement of the civil rights law in the Constitution itself. In the words of James Garfield, future president, then a representative, they wanted to embed the civil rights law in the eternal firmament of the Constitution. All that so far, I think, is like we're all on the same page, probably. The question becomes which clause of the Constitution does this work of constitutionalizing the Civil Rights Act? And my claim is the Privileges or Immunities Clause. For a couple of reasons, I don't have time to go into all of them, so let me just say a few things. One is note the parallel to the Civil Rights Act. The Civil Rights Act begins with a declaration of citizenship and then says citizens of the United States, as such citizens of the United States are entitled to equality and civil rights under state law. How does the 14th Amendment begin? All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. It's not identical language. It extends beyond mere race, right? Other arbitrary discriminations are prohibited, but it's certainly parallel. It's also parallel to the Privileges and Immunities Clause of the original Constitution, the Comity Clause. The citizens of each state shall be entitled to all privileges and immunities of citizens of the several states. In the several states, I don't know if you covered this in Comma 1, but it was basically an interstate non-discrimination requirement. So if a citizen of Massachusetts is traveling in Texas, Texas has to give that citizen of Massachusetts the same privileges and immunities, whatever they are, that Texas gives its own citizens. You can't treat the citizen of Massachusetts as a foreigner. Well, if I'm right, then the Privileges or Immunities Clause does for intrastate discrimination what the Privileges and Immunities Clause did for interstate discrimination. The language does the work. That's usually the hiccup. Right? A bridge was often used to say your rights are abridged compared to some other person's right. A class, a more favored class, had a higher set of rights, an enlarged set of rights compared to a disfavored class, which had a abridged set of rights. Then it says privileges or immunities of citizens of the United States. Okay, this is usually the hiccup number one. Doesn't that sound like federal constitutional rights? I mean, that's Kurt Lash's argument. But this reasoning collapses upon a moment's reflection, namely that as United States citizens, we have privileges and immunities from multiple sources of rights. Yes, we have privileges and immunities from the Constitution. We also have privileges and immunities in federal statutes. What does it mean to incorporate that? You had to be, I mean, in my mind, I sometimes think I'm still living in the 19th century, because I read and write about all this. You had to be a United States citizen to get a license to captain a coasting vessel, to be in the coasting trade. You needed to be a U.S. citizen to engage in trade with the native tribes. You had to be a U.S. citizen to get a passport, right? So there are also, what about the patent laws? All sorts of privileges and immunities that we have by virtue of federal statutes. And we have privileges and immunities under state law. as U.S. citizens, I have privileges and immunities under my state constitution, under state law, under state and general common law. So it doesn't make sense to limit the phrase privileges or immunities of citizens of the United States only to one subset of those rights, or at least federal constitutional rights. It makes much more sense to think that they refer to all of the privileges and immunities of U.S. citizens that it is within the power of the states to abridge in the first place. The kinds of rights under state law, civil rights under state law. Okay, maybe the clincher, I don't know, I saved it. All but one member of Congress connected the privileges or immunities clause. I mean, who spoke about the matter, right? Connected the privileges or immunities clause with constitutionalizing the Civil Rights Act. One exception, who said it was maybe equal protection. So overwhelming evidence that the privileges or immunities clause does not incorporate the Bill of Rights. It is merely this anti-discrimination provision. But this brings me to my next point, which is why not equal protection? Right? If equal protection requires equal rights, then isn't my reading of the privileges or immunities clause totally superfluous? And it would be. But I hate to break it to you, what you all learned in con law, the equal protection clause does not mean what you learned it means. Equal protection does not guarantee equal rights. It guarantees equal protection of the laws, which was a much narrower concept. Protection of the laws was the legal concept, was the legal protection the government had to give you against private interference with your private rights. What happens when you have a neighbor that commits a trespass against you, or another tort against you, converts your property, commits an assault or battery against you? Mob violence, Lynch's law, was the quintessential example of a failure of a state government to provide protection of the laws. What is protection of the laws then, principally? It's judicial remedies. You have to have some method of recovering against other private persons who interfere with your enjoyment of rights. And then protection from private violence. Okay, don't believe me. Why should you? I'm just a young, new constitutional law scholar. Here's what William Blackstone said in his commentaries on the laws of England. The remedial part of the law is the method of recovering and asserting rights when wrongfully withheld or evaded is what we mean when we speak of the protection of the laws. Remedial rights. Chief Justice Marshall, Marbury v. Madison, the very essence of civil liberty certainly consists in the right of every individual to claim the protection of the laws whenever he receives an injury. Remedial rights. Okay? So the equal protection of the laws clause doesn't constitutionalize the Civil Rights Act of 1866 because it doesn't require equal civil rights. It doesn't require equal laws. It simply says whatever rights you have under the law, you are entitled to be protected so that you can enjoy and exercise those rights free from the Ku Klux Klan, okay? Free from other private parties trying to interfere with your enjoyment and exercise of those rights, okay? So if I'm right about that, then I think, again, the privileges or immunities clause is the only clause that does the necessary work of constitutionalizing the Civil Rights Act. Okay, now I'm slowly getting into the free speech. One more point about the incorporation. The argument in favor of incorporation is often look at all the free speech and press rights that were denied. The enslaved people, abolitionists, they were denied free speech and press rights. The newly free population denied Second Amendment rights. Yes, true, but you don't need incorporation to solve that problem. Each and every state constitution had a free press and free speech clause. As of 1861 and as of 1868, every single one. Every single state allowed white people to keep and bear arms with different restrictions. And the problem was the discrimination in the provision of this right. Well, if freedom of speech, press, the right to bear arms are civil rights under state law, under the state constitution. If white people can do it, then the privileges or immunities clause now says black individuals, black citizens, they are citizens, are entitled to these same rights too. And the protection of the laws clause says, and you're entitled to be protected against private people who try to invade your rights. Okay. I pulled out a quote here. Here's an example of why I think this view is consistent with also some black voices. So there were a series of what were called colored conventions in throughout the 1860s, which and before, actually 1830s, 40s, 50s, where these conventions of largely free black persons, many of them citizens of northern states, but not all, some just free black persons in southern states, they would get together and they would explain their demands, what they want. Here is one from Alabama in 1867. This is what they said. As there seems to be considerable difference of opinion concerning the legal rights of the colored man, it will not be amiss to say that we claim exactly the same rights privileges and immunities as are enjoyed by white men. We ask nothing more and will be content with nothing less. Color can no longer be pleaded for the purpose of curtailing privileges, and every public right, privilege, and immunity is enjoyable now by every individual member of the public. Again, the key thing wasn't to, sorry, I keep doing my subliminal message. The key was not to nationalize rights. It wasn't to incorporate the Bill of Rights. That was on no one's horizon. That was on no one's intellectual horizons. Why? Because they all presumed that all free governments had to secure certain natural rights, that all free governments did in fact secure such rights, and that all the southern states did in fact secure such rights to a portion of its population that it denied to others. The problem was slavery made them corrupt in the way that they enforced these existing protections, right? And so, okay, so that's the affirmative argument. I think this frame, as in from an originalist perspective, better supports a lot of the arguments that Professor Carter draws from the slave narratives and other originalist accounts, including Incorporation. So for example, Professor Carter, in a very important part of his paper, and he briefly mentioned it here, but it explained that state action, what's the big deal? State action wasn't the big deal. The Ku Klux Klan was the big deal. The problem was the states could pretend you had all these rights, but if they never stopped the Klan from coming in and taking away your firearms and burning your printing presses and threatening you and intimidating you, and hanging you from tree limbs because of the speech you made, then what good are those rights? Well, the Equal Protection of the Laws Clause, under the correct original meaning, is a state inaction clause. It requires the state to supply protection of the laws, affirmative legal protection, and if they don't, the federal government can step in. I think that accounts for this private action problem. And then there's this viewpoint discrimination. The viewpoint discrimination is de facto the viewpoint discrimination doctrine is de facto encompassed by my reading of the Privileges or Immunities Clause. Why? What is free speech? Inherently, free speech is the right to have a different viewpoint about something, right? You can't say, well, nobody's allowed to speak against slavery, so everyone's equally unallowed to speak. But that's not free speech, that's unfree speech. By definition, it's not free speech if you can't speak your mind. If those who support slavery are allowed to speak in favor of slavery, then the Privileges or Immunities Clause says those against slavery have the same right. Viewpoint discrimination is effectively baked in to the anti-discrimination reading of the Privileges or Immunities Clause. However, what about flag burning? What about student speech? What about protesting at a dead soldier's funeral? What about advertising violent video games to minors? What about prohibitions on stealing valor, pretending you're a Medal of Honor recipient when you're not? All 5 issues, the Supreme Court, through Incorporation, has determined that the federal First Amendment means one thing and imposed it in all 50 states. Under my view, viewpoint discrimination can't do that. That's baked into the Privileges or Immunities Clause. But I think it means Texas could prohibit flag burning. I think it means California could prohibit the sale of violent video games to minors, right? As long as they do it equally and don't discriminate. You can't say, well, only Black citizens, you can't burn the flag. Black citizens aren't allowed to take a knee, but white citizens can. I mean, well, that also gets into viewpoint problems, right? But the point is, all of these things that have been incorporated via the First Amendment, I think would be left to the states to experiment. But the key point is viewpoint discrimination would still effectively be baked in, and there's this protection against private action, private interference with your rights. I'll stop there because this is about the First Amendment. I have lots more I could say, about like Brown v. Board. I think my reading is the only reading that gets us to Brown v. Board if you're an originalist. Now, maybe you don't care about originalism, right? For those who care, maybe you should also like my reading for that reason. But there are lots of interesting implications of this approach. So that's what I just wanted to start with. I'm happy to take questions and hear Professor Carter's response. And I know we only have 20 minutes left, but happy to start the conversation.
Professor Carter, your response, please.
Yeah, I'll just offer a very few brief thoughts, but I really am interested in the discussion, so I'll be brief and leave most of these as rhetorical for Ilan, unless one really jumps out at you as worthy of response. The first is, it would have been great if we had gotten together before I started my article and before you wrote your book, because it's given me a lot of food for thought. I want to actually sit with it for a while, but I can see how it pertains to several things in my article that started from the same common default assumption among constitutional scholars about where the nationalism of rights comes from. So I'm not sure I agree with you, but I think it is highly informative. The second thing I wonder about, with regard to your privileges and immunities theory, and I offered this really as rhetorical. If we think about it as a non-discrimination mandate, then it raises two questions for me, one micro and one macro. The micro one is whether it would embrace disparate impact theory then, whether the neutrality and protection of rights that is required would only kick in when there is purposeful discrimination, a la Washington versus Davis, or whether it would apply in cases of significant, at least disparate impacts. The macro level issue that it raises for me, it reminded me of an episode of the TV show BoJack Horseman, where women start engaging in the widespread carrying of guns, and all of a sudden the country outlaws guns. And one of the main character, Diane, says, I guess now we know that America hates women more than it loves guns, right? So I wonder, by that same token, does America hate Black people so much that it would compromise its own rights in order to avoid giving equal rights to Black Americans? I don't know. But I do think about that as well. But thank you for really, really interesting talk, and I look forward to reading your book.
And my book came after your article, so we should have got together before I wrote it, but I'm glad it's helpful for both of our future projects. I will say, Professor Carter, it's not just hypothetical. I'm pretty sure that's what Texas did in 1871. I think it just banned guns. Now, the question is, I think it banned the sale of guns. I'll have to go back and figure out what the 1871 statute was. But so what? So now just all the white people who already have guns are the only ones who are allowed to have guns? That itself would be problematic, which goes to your first question, is disparate impact analysis. How does that come out? I think it's largely consistent with the modern doctrine, and maybe even more favorable to the claims, which is what Professor Carter is getting at, because it says no state shall make or enforce a law which shall abridge the privileges or immunities, which means there can be laws out there that are facially neutral, like the Yiquo case, right, the laundromat license case, where in practice it is administered in such a way that it abridges the rights of a class of citizens, like Chinese applicants in that case. I think this would be facially neutral, the prohibition on guns, with a discriminatory intent, obviously. But I don't know if that discriminatory intent is enough. You need a disparate impact, but you have the disparate impact because only white people were grandfathered in, you know? I mean, so now, what if the legislator passes a law that has no discriminatory intent? They really think, oh, this is going to be a good thing. And in fact, it creates an abridgment because for whatever reason, only elite white people who went to Harvard can access it, okay? Well, I think that's an abridgment. I think that whatever, unless it's truly reasonably related to the purpose of whatever the right is, but come on, like a right that is regulated in such a way to limit it to white people who went to Harvard, right? Probably that's an abridgment, even if you can convince me that it wasn't enacted with a discriminatory motive. So I think it's actually more favorable in that regard. Lots of food for thought on a lot of this. Thank you, Mr. Carter.
Absolutely, tons of food for thought, and we want to open it up to questions now. So if you folks have questions, anyone who's here can raise their hand. Folks who are in the chat can go ahead and throw stuff in there. Yeah, any questions from folks?
Or are we both so obviously right that, but again, other than just to emphasize, other than like Professor Carter, this isn't the issue. This is not what he's writing on. He writes within the incorporationist framework, right? He assumes incorporation is correct. That's what I'm tackling. But then on all the lower order, outcomes on which the slave narratives speak and these other Black voices spoke in the 1860s and so on, I think we're very much aligned on a lot of these, which is kind of interesting. So maybe we should have found more to disagree on the lower order, but.
Well, yes, go ahead.
So I believe before, so the Article 4, Section 2, the I clause, before the Civil War, there were scattered claims, I believe, by free northern blacks who went south and tried to claim rights under that PI clause. How does that history sort of influence your reading of the construction PI clause?
Yeah, that's a great question. So again, the clause says a northern citizen traveling south must be treated the way the South treats its own citizens, right? That's what the clause says. Well, what happens when a free black citizen of Massachusetts is traveling to South Carolina? Is South Carolina going to give that free black citizen of Massachusetts all the privileges and immunities of white citizens in South Carolina? Well, what they argued, and this occurred under several very distressing episodes. Okay, so there was the second Missouri controversy, where Missouri, after the Missouri Compromise, proposed its constitution necessary for admission, and it proposed to exclude free blacks. Right? It said, no free person of color can come into the state. Well, if you're a free black citizen in Massachusetts, you have a right to go to Missouri and enjoy the privileges and immunities of citizens in Missouri. It doesn't violate the Constitution. There was a series of Seaman Acts after the Vesey plot, which I believe Professor Carter talks about the Vesey plot, but maybe I'm misremembering. I think there was a imagined slave uprising in South Carolina. They concluded that it was the free black Northerners that were stirring up the pot, so they passed a law that said any free black seaman coming into a southern port is to be imprisoned while the ship in the port at the expense of the ship owner. And if the ship owner can't pay the expense, the free black sailor would be sold into slavery. Okay, what about their rights as citizens under the Comedy Clause? Well, what the South argued, was free blacks may be citizens of Massachusetts and New Hampshire and whatever, but they aren't citizens of the United States within the meaning of the Constitution, such that they're entitled to rights under Article 4 and Section 2. That is what Chief Justice Taney held in Dred Scott v. Sanford. He said if they were citizens within the meaning of the Constitution, what would be the implications under Article 4? Oh my God, they would be able to travel without passports, internal passports. They would be able to speak on whatever white people are allowed to speak about. They'd be allowed to own guns without special licenses. So he concluded they couldn't possibly be citizens of the United States. Well, the first sentence of the 14th Amendment solves this question once and for all. It declares them to be citizens of the United States, right, entitled to the privileges and immunities when traveling to other states. Now, what is the Privileges or Immunities Clause does a bit more, right? Now, the Privileges or Immunities Clause, right, guarantees intrastate non-discrimination, right? Why? Why? How did we get there? Well, because it's now every state must secure the privileges or immunities of citizens of the United States in those states, including the privileges to contract property and so on. These are understood to be the privileges of citizens of the United States. So it takes it one step further. Now, and so I'll stop there. But does that give you some?
Yes, thank you.
Professor Carter, do you have any thoughts on that question? Okay. Any other questions from folks? Yes, please.
Right. So I have a question. Under either of your readings of freedom of speech, as it applies to the states, either as an equality provision or through incorporation of the First Amendment, do state and local governments have any sort of obligation to equalize speech, or are they required to take a hands-off approach and, allow speech to go however it goes in the free marketplace of ideas? Does either of your, to use Justice Holmes' phrase, does either of your readings encompass sort of a free marketplace of ideas notion of freedom of speech, or does it require something of the government, either affirmative or negative, to sort of equalize speech among different actors within the system of American society?
Yeah, I can weigh in briefly. I'm speculating here. Ilan and I might end up in the same place for different reasons. So in the article, I don't take a position on that kind of question. What I'm trying to do there is more descriptive than normative, right? And to explain some, but not all, doctrinal implications of interpreting the First Amendment in the way that I did. I can say from the slave narratives and the statements of Republican congressperson as well as abolitionists that the dominant view expressed seems to have been the need for the government to actually protect speech equally. And the enslaved persons and their allies believed that given an equal playing field, that their arguments would win out. Their concern was that the playing field had been tilted. I hesitate to say, and therefore that leads me to think that all a state is required to do is to take a hands-off approach, because the playing field, if you will, may be tilted in other ways that require some affirmative steps by the government to actually equalize the speech. So in my First Amendment and con law classes, we talk a lot about, if one speaker has a megaphone and the other speaker is muzzled, the speech inherently can't have equal impact in the marketplace. So someone has to either lower the volume of the microphone or remove the muzzle on the less privileged speaker. So the article doesn't really take a position on that particular issue. Unsurprisingly, given my other writing, though, I think that the government has a affirmative obligation to ensure that rights can be effectuated equally and that they're not just treated facially equally. So substantively, I would say that I do believe there may be scenarios where the government is required to take action, affirmative action, if you will, in order to ensure that all speech can reach the marketplace with equal valence. Not in every scenario, I hasten to add, right? I'm not saying that the government has a duty to boost all signals at all times. Right? So I'm a tenured law professor. I don't really need the government's boost of my signal very often. I'm not suggesting that there ought to be countervailing viewpoint discrimination in order to solve an existing problem of viewpoint discrimination. I'm simply saying there may sometimes be structural inequities that do require governmental intervention.
Professor Wurman, any thoughts?
I have some, but I'd rather take another question. I largely agree with what I just heard, so
any other
that's a
questions?
great question.
Any other questions?
Most people think I'm crazy when I hear this argument, so I'm surprised that yes, ma'am. Good.
I barely remember anything from 1L, but
Probably
didn't
better.
Thomas neuter the privileges and immunities clause?
The Slaughterhouse?
Yeah.
Yes, and the big question is why.
Yeah, so
If I'm right, that's another big argument. Again, well, a lot of people think Slaughterhouse is wrong, though, right? But a big argument is well, if this is so obviously the right reading, and it is, then why did the court get it so wrong? What happened, right? In the Slaughterhouse cases, the court basically said, well, it does only refer to national privileges and immunities, and very quickly after that it said, oh, but the Federal Bill of Rights only applies against the federal government. So if it refers to national privileges and immunities, but the Bill of Rights doesn't apply against the states, then what does the clause do? What does the clause do? It protects your right to travel on navigable waters. Because apparently the states were really interfering with that one. Or they were, on the high seas. I'm not sure the last time the states kept ships of war, not allowed to. Article 1, Section 10 actually, trying to prevent you from exercising your rights on the high seas. Anyway, so it basically made it a nullity. And the question is why? And the best answer I have is because, as the court said in Slaughterhouse, could it possibly have been intended by Congress to revolutionize the division of federal and state power? They ruled in the Slaughterhouse the way they did for the same reason that Reconstruction ended in 1877 the way it did. Because they were tired of this issue. They were tired of federal interference in the states. They were tired of federal troops in the state. We got tired of 3,000 residual troops in Afghanistan. Try tens of thousands of American soldiers occupying sister states, right? They got tired of it, and so they adopted their own intellectual backgrounds, prejudices, biases, of the same way that Chief Justice Taney, I don't think, accurately reflected the founders. Right? Read Benjamin Curtis's dissent. It obliterates the argument that free blacks weren't citizens. What were they doing? They were adopting the intellectual arguments of their own aristocracy, in Taney's case, Southern aristocracy, the 1830s, 40s, and 50s. And the Supreme Court justices had their own pre-Civil War prejudices. And I think that's how they got it so wrong. And it is a problem for, well, it's not a problem. I get paid just the same. That's the great part about being an academic. But it does raise the question that you raised.
Thank you.
Can I interject just two brief things? First, I'll double down on what Ilan said. There is no other way to explain the result in Slaughterhouse and in the civil rights cases other than what Professor Darren Hutchinson calls racial exhaustion. I can commend an article by that title by Professor Hutchinson to any of you who are interested in this issue in our jurisprudence. And so he talks about our contemporary debates, like we've done enough, we elected a Black president, now all problems are solved, right? And he says, that sounds like a new thing. In 1877, the white North began displaying exhaustion with remediating the legacy of 250 years of slavery, 12 years after it ended. Right. And so that phenomena is not new. The only other point I was going to note is, Ilan, you're going to get kicked out of the Originalist Club for being iconoclastic. Right. And so I say that half jokingly, but I want to note, again, I am not an originalist. I believe originalism is a valuable tool, but I don't have an ex-ante commitment to it. What I do have a problem with, and this is shared by folks who call themselves progressive originalists, is the assumption that any constitutional interpretive methodology will always and only lead to a single set of results, right? And I think Ilan's work is demonstrating that if you enter into the project honestly, you might not always get the results that align with your political position, not to infer what your politics are at all, Ilan. I'm simply saying that the way you're going into this is quite different than some of the priors that I think many originalists bring with them to these analyses.
Yeah, I will say I presented a paper on Reconstruction era rights, social, political, civil rights distinction, which you may have heard just this last weekend. I actually haven't been home in 5 days. And I was accused of being iconoclastic and disruptive, but so an originalist called me iconoclastic. It was an originalism conference. And then there was non-originalists there too. And one was very gleeful at the fact that I was being disruptive in the sense of, everything originalists thought was true. Ilan now says is wrong. There's no right answer, so how can originalism work and be constraining? So it may be iconoclastic, but as I said, I get paid just the same.
Well, all right, folks, that is our time. I want to say thank you to the First Amendment Center for hosting this event. I want to say thank you to Professor Carter for joining us via Zoom, and Professor Wurman, we appreciate your time. I would encourage you all to go and read the Second Founding in the First Amendment, which is an article within Volume 99 of the Texas Law Review, and of course, Professor Wurman's book, which is here. And of course, thank you guys for joining, and thank you for listening to this.